Hello and good afternoon again. Now, as our second speaker, we have Dr. Lourdes Peroni, who is Senior Lecturer in Human Rights at the Helena Kennedy Center for International Justice at Sheffield Hallam University. Let me mention about her working area a bit. Her focuses of teaching and research are equality and non-discrimination, gender and migration, gender-based violence against women, and feminist legal theory. And the title of her presentation is Gender Equality in the Istanbul Convention. Now the floor is yours, Dr. Peroni.
Well, good afternoon, everyone. Thanks very much for such a generous presentation. Thanks very much for inviting me to be part of this excellent summer school. I mean, the program looks absolutely great, and I'm sure everyone has been enjoying the sessions throughout the week. So yes, thanks very much for having me. I'm very excited to be here today and be able to share with you some thoughts on gender equality in the Istanbul Convention. Before getting started, I just want to say one more thank you to everyone. I see a lot of people are present in today's session, so I want to thank you all for being here. And I'm already looking forward to the discussion, the questions and comments you may have after the talk. So indeed, so the topic of my presentation is gender equality in the Istanbul Convention. And what I would like to do throughout the presentation is to make a big point, which is the following. I would argue that the Istanbul Convention obviously is an instrument that aims to tackle, to combat, to eliminate violence against women, gender-based violence against women. But I would argue that the Istanbul Convention is not just that, but also, and very importantly, the Istanbul Convention is also a gender equality instrument, and quite a strong gender equality instrument. And as I will try to show in my presentation, that is because the way in which the convention frames the problem of gender-based violence against women, and also because of the ways in which the convention responds to the problem of gender-based violence against women. So that is a major point I'll be trying to make throughout my presentation, the fact that the convention is also a gender equality instrument. And as I mentioned, this is the case, I would argue, because first of all, the way in which the convention frames the problem of gender-based violence against women. So as you probably noticed, those of you had a chance to, I guess most of you, if not all of you, had a chance already to read the text of the convention. And you may have noticed that in the preamble, the drafters of the convention define or understand the problem of gender-based violence against women as a manifestation of historically unequal power relations between women and men. So here the convention sees the problem of gender-based violence against women as rooted in historical gender inequality or inequality between women and men. And the preamble of the convention frames this problem not just as a manifestation of unequal power relation throughout history between women and men, but also as a mechanism. So violence against women is also a mechanism by which women are forced into a subordinate position in society. So you may have heard in different talks, you may have read in the literature, you may have seen in other conferences that people usually say that the convention is both, that gender-based violence against women is both a cause and a consequence of gender inequality. So this is exactly what this preamble is trying to show. And actually this understanding or this framing of the problem of gender-based violence against women is not new. The convention takes this formulation from previous human rights instruments from the 90s, including, of course, the CEDAW Committee General Recommendation number 19, also the UN declaration that seeks to combat violence against women, also a declaration from the 90s, and the Inter-American Convention that seeks to combat violence against women. All these previous instruments, human rights instruments from the 90s, frame the problem of gender-based violence against women as a gender inequality problem. And the Istanbul Convention takes these developments and follows this formulation and this understanding or framing of the problem. So once the convention, the Istanbul Convention in this case, following previous instruments, frames the problem this way, a series of implications flow from this. And these implications are in essence very strong equality efforts made throughout the text of the convention. And one can see, I would argue, these efforts mostly or most evidently in three parts of the convention text. So first of all, in the goals of the convention, so in the very first article of the Istanbul Convention. Second, in the article that sets out general equality and non-discrimination obligations for states, so that's Article 4 of the convention, and also in the prevention obligations of the prevention chapter, including obviously the first chapter of that, the first article, sorry, of that chapter, Article 12, and the series of other articles that follow in that or that are also part of the prevention chapter. So I'll go over each of these parts of the convention in turn to explain why then the convention frames, as a result of the framing of the problem, it frames also the responses to the problem from an equality, from a gender equality and non-discrimination perspective. So first of all, as I mentioned, the goals of the convention, that's the very first part when one can see probably most evidently the commitment of the Istanbul Convention with gender equality, because in this part of the convention, that's Article 1, by the way, among the goals or the purposes the convention seeks to achieve are contributing to the elimination of discrimination against women and also to promoting substantive equality between women and men, including by empowering women. So this is an equality goal that the convention sets itself to achieve. And it's not just any kind of equality. The convention speaks expressly of substantive equality, which, as you know, is a very robust conception of equality, because unlike formal equality, substantive equality actually seeks to achieve equality on the ground, in reality, in the facts, and not just formally, not just an equality of opportunities, not just equality before the law, but actually equality in reality, in this case, for women and men. So this goal of achieving, or this purpose that the convention imposes on itself of achieving substantive equality, substantive gender equality, is the first manifestation of the commitment that the convention has with gender equality as a way of eliminating gender-based violence against women. So the second part of the convention, as I mentioned earlier, where one can evidently or quickly find the convention's commitment to achieving equality, gender equality more precisely, is Article 4, where one can find a series of general non-discrimination and equality obligations that the convention imposes on state parties. And in this article, one can find that the convention asks from states the kinds of obligations, positive obligations, by the way, to achieve not just de jure equality, but again, de facto equality. So for example, among the de jure equality obligations that the convention asks from states in Article 4, one can find the obligation to enshrine in national constitutions or any other pieces of legislation the principle of equality. Another de jure equality obligation is that of abolishing those laws that are considered discriminatory towards women. And again, these are not just the jure positive or the jure equality positive obligations. but it also includes substantive or de facto positive obligations, such as, for example, making sure that that principle, equality principle that states are asked to enshrine in their laws, they should also make sure that that principle is actually practically realized. So that practical realization of this principle that alludes to the need to take that to another level, to a ground level, to a reality level, and not just to the law level. That article also, among the de facto equality obligations demands from states. Another example is the obligation to abolish discriminatory practices. So here again, it's not just a matter of abolishing discriminatory laws, so the jure discrimination, but also practical discrimination practices that are discriminatory towards women or against women, actually. So these are examples of the manifestation or the commitment that the convention has to achieving equality, gender equality. Again, not just the goals that the convention sets itself to achieve, but also the kinds of equality and non-discrimination obligations that the convention asks from states that I was just mentioning very briefly. The third place of the convention where one can find a strong commitment of the drafters to gender equality is the prevention chapter. So in this chapter, one can find a major general obligation that in essence asks states to promote societal changes, or social cultural changes in societies, the kinds of changes that aim to modify attitudes, beliefs, stereotypes, prejudices, whatever, or patterns of behavior that have historically sustained the idea that women are inferior to men in society. So the system of beliefs, of practices, of traditions, of prejudices, of stereotypes that have kept women in a subordinate status in society. So this general obligation, the first general obligation mentioned in the prevention chapter, again, seeks to dismantle basically the views that have historically in society sustained the gender hierarchy that the convention is trying to dismantle. What is interesting also in this chapter is that what flows from this general obligation that one may call, to summarize, one can call an anti-stereotyping obligation, which is actually, between brackets, just a short comment. This obligation is taken from Article 5 of the Convention against the elimination of all forms of discrimination, known as the CEDAW Convention. So it's taking, the wording is very similar, but it's not just, that kind of wording is not just present in CEDAW, so the CEDAW Convention. It is also present again in instruments from the 90s, like the UN Declaration against violence against women, and also the Inter-American Convention that seeks to eliminate violence against women, which is known as the Belém do Pará Convention. So one can find that anti-stereotyping clause, that kind of anti-stereotyping clause present in previous human rights instruments as well, and the Istanbul Convention follows that formulation present in those instruments. Again, in this prevention chapter, so that is the general obligation, major general obligation set out in that chapter. But what is equally interesting in this prevention chapter is that the convention asks states to put in place quite a broad and rich range of measures that ultimately aim to tackle these negative views of women, the kinds of views that kept women in inferior positions in society, that are sustained by different sectors or different groups of people or actors in society, including the public at large, the professionals that deal with or that respond, the authorities and professionals that deal and respond to violence against women, such as health professionals, social services professionals, judges, prosecutors, the police, of course, the media, perpetrators, and young pupils in schools and universities, including children. So it addresses the measures that flow from this general obligation, anti-stereotyping obligation, address all these sectors of society through different kinds of mechanisms that range from public awareness campaigns, education materials in school, training, again, of professionals that who work with victims of gender-based violence, especially to avoid that victims are re-victimized, or to prevent secondary, what the convention takes as secondary victimization. Also to involve the private sector and the media in a way that they can tackle images that appear in the media that are degrading of women, or sexual content or sexual violence and violence in general that may be harmful, images that may be harmful towards women. So it is interesting that this prevention chapter tackles not just different sectors of society through different kinds of measures, but I think it holds great potential to promote these changes that the Istanbul Convention is trying to seek out in society by addressing various societal levels. Again, the media, schools, public at large, police, I mean, any other authorities responding to violence against women. So let me now just go to one aspect, one equality aspect of the convention that I left for the end of my presentation on purpose, because I would like to take a little bit more time explaining this, and that is the issue of intersectionality, more specifically intersectional discrimination. Those of you, which I assume are most of you, who had a chance to read the text of the convention and perhaps the explanatory notes of the drafter, and also check the work of the monitoring body, so the body that monitors implementation of the convention, namely Grevio, may have noticed that intersectionality, I mean, it's not really present in the text of the convention. So as you know, just very briefly, intersectional discrimination, more concretely, is the kind of discrimination that is experienced by different groups of people, in this case, by different groups of women, differently because of the interaction of or the intersection of different systems of power, or these different systems of oppression, such as, for example, sexism and racism, or racism and migration rules or migration status, sexism and ableism or classism. So different systems of oppression that interact to put certain groups of people, in this case, certain groups of women, at an even stronger discriminatory position. So they work together to reinforce discrimination. So intersectional discrimination, I was saying, is not so much present in the text of the convention. If you look at it, the language of intersectional discrimination is not used, is not expressly used in the text of the convention, although the convention does address the concerns or certain obstacles or barriers that certain groups of women who are victims of gender-based violence may face, more specifically migrant women. So there's a special section of the convention devoted to that, and also to asylum seeker women. So it does, to some extent, take into account the concerns and the barriers that these groups of women, for example, may face. But the word intersectional discrimination is not present there, and there's not much acknowledgement of intersectional discrimination in the text of the convention. But as I would try to show, and this is why I left this part of the presentation for the very end, I'll try to show by looking at the drafter's explanatory notes and also at the work of Grevio, how actually the convention taken as a whole and as a living instrument does address intersectionality quite strongly, I would argue. So first of all, if one looks just at the text, as I was saying, there are sections devoted to the concerns of certain groups of women who are victims of gender-based violence, like women asylum seekers, migrant women. But you may have also noticed that there is, in Article 4, by the way, there is a non-discrimination clause, so a prohibition, a general prohibition of discrimination that on different grounds that that ultimately seeks to avoid that states implement the convention in a discriminatory manner. So put it another way, this is a provision, and it is found in Article 4 of the convention, that is trying to have the convention implemented, all the provisions of the convention implemented in an equal manner, particularly those provisions of the convention that seek to protect women who have already been victims of gender-based violence. So in this part, in this paragraph of Article 4, in this non-discrimination clause, you will find that there is this prohibition of discrimination based on different grounds, which are the usual grounds, so the grounds that you would usually find in other non-discrimination clauses of other human rights instruments. So for example, in the European Convention of Human Rights, you will find, a general prohibition of discrimination on the basis of race, language, religion, political opinion, association with a national minority, property, birth, sex. So those are grounds usually mentioned in several human rights conventions when they speak of non-discrimination. And that's the case of course, the European Convention of Human Rights, where from where part of these grounds, this list of grounds, have been taken and incorporated into the Istanbul Convention. But interestingly, the Istanbul Convention goes further in the list of grounds on which discrimination is prohibited. And the drafters added a series of other grounds that they thought were particularly relevant to the subject matter of the convention. And these added grounds, or the grounds that the drafters of the convention added to the usual list of prohibited discrimination grounds, include gender identity, sexual orientation, age, state of health, disability, marital status, migrant and refugee status, and other status. So it's like other non-discrimination clauses is an open clause because it says other status, opening the door to the inclusion of other grounds of discrimination. But it does include quite a large and substantive list of grounds that are usually not included or have not been included in previous non-discrimination clauses of human rights instruments. So that's one preliminary remark I wanted to make that concerns the non-discrimination clause in the Istanbul Convention, and then just make a couple more remarks that are more strictly related to intersectionality. So again, if one looks at the text of the convention, one may think that there's not much on intersectionality or intersectional discrimination, to be more concrete, in the text of the convention. But if one takes a close look at the explanatory report prepared by the drafters of the convention, and again, if one looks at the reports adopted by Grevio when doing its monitoring work, one can see that there is a lot more on intersectional discrimination. So for example, the drafters themselves acknowledge already when they prepare the explanatory notes to the convention that there are certain groups of women who might experience multiple forms of discrimination. And among the examples the drafters give and the examples with which the drafters are particularly concerned are women with disabilities, ethnic minority women, Roma women, and women living with HIV. So the drafters already acknowledge a concern with multiple, what they call multiple forms of discrimination, which again can be also regarded as intersectional discrimination. But I would argue that it is Grevio's work that has taken, I think, intersectional discrimination concerns to another level. In its reports concerning different countries, Grevio has paid very close attention to intersectional discrimination against different groups of women who might get victims or who are victims already of gender-based violence. And these groups of women with whom the convention, the Grevio has shown concern include Sami women in Sweden, Egyptian women in Montenegro, women with disabilities, women living in rural areas, migrant and asylum seeker women who are already in the convention text, and as well as lesbian, bisexual, and transgender women. Just to mention a few examples of different groups of women with whom the committee of experts, Grevio, has expressed specific concerns. And what is interesting about Grevio's work when it comes to intersectional discrimination is also that it has developed quite an interesting range of recommendations aimed at different states. And among these recommendations to tackle intersectional discrimination experienced by these different groups of women are, for example, improving access, recommendations that ask states to improve access of these groups of women to protection and support services. Also, among its recommendations, Grevio has asked states to include specific indicators on gender-based violence affecting certain groups of women when collecting data on gender-based violence. Also, when designing, implementing, monitoring, and evaluating policies to combat violence against women. So those are just a few examples of the nature of the recommendations that Grevio has asked states to put in place to address intersectional discrimination or the concerns of specific groups of women who might be victims of gender-based violence or who have been victims of gender-based violence. In its reports or in its monitoring work, Grevio has also identified interestingly quite a big range of barriers that different groups of women may experience. For example, when trying to seek support and when trying to seek protection from the authorities. And these barriers include socio-cultural barriers, practical, legal, geographic. So for example, Grevio has observed how stereotypes of ethnic minority women have undermined state responses to requests for protection from gender-based violence. So here we have a concern with stereotypes of a specific group of women, ethnic minority women, which would be a social cultural kind of barrier, right? It has also, in the same vein, has also worried about prejudices and discrimination against lesbian, bisexual, and transgender women, especially when these groups of victims are trying to access support services and shelters. So again, a social cultural barrier manifested in prejudice and discrimination against certain groups of women who have been victims of gender-based violence. Grevio has also highlighted language barriers, and it has basically asked state authorities to ensure that language does not turn into a de facto ground of discrimination against women who are victims of violence and who do not speak the language of the country where they are living, where they are based. So that's another barrier that has been identified by Grevio as a barrier that may be experienced or may be encountered by a certain group of women. They've also highlighted some practical, legal, administrative obstacles that may impede access to support services, including shelters, particularly for women with intellectual disabilities, also for women asylum seekers and women with insecure resident status. And again, I mentioned that one kind of barrier that Grevio has identified is that is geographical barriers. So for example, when expressing concerns about the kinds of barriers that women living in rural areas might experience, Grevio has noticed that geographic isolation contributes to their lack of information about available resources. I mentioned earlier that women with disabilities is a group of women with whom the monitoring body Grevio has expressed its worries. And regarding this group of women, for example, they have identified several barriers that may make it difficult for these women to seek support if they become victims of gender-based violence, or for example, the lack of information on available support services. So this is listed among the extra hardships that women with disabilities may face. Grevio has also highlighted the difficulties in accessing information about their rights, about receiving adequate support and benefiting from existing specialist services for women victims of violence, or women with disabilities who are victims of violence. And one important barrier that Grevio has highlighted when it comes to women with disabilities who are victims of gender-based violence is that of a generalized lack of understanding of the gender-based violence to which women with disabilities are exposed, and the resulting risk of being stigmatized and disbelieved when they speak out. So this is again kind of a social cultural barrier, the disbelief that and the stigma that this group of women may face when they speak out. Another group of women that Grevio has shown concern about is those women who are dependent, financially dependent on their spouses or partners, and also those who are dependent on their spouses or partners for the resident status, so migrant women. And in this regard, Grevio has recalled that financial imbalance renders women economically dependent, and that this economic dependency in turn may be a fertile ground for violence. So I've tried to slow down a little bit and try to explain in more detail this aspect in which the convention's commitment to equality manifests itself, especially because of the very interesting and thorough and deep work that Grevio has done in this respect. So again, even though there might not be much on intersectional discrimination in the convention's text, apart from references, apart from special sections, which is quite a lot already, actually, special sections devoted to migrant women, asylum seeker women, and also apart from this general non-discrimination clause. But its monitoring work, its monitoring body has done a terrific work in filling in that gap, that intersectional gap that one may argue is present in the text of the convention. So to sum up, then, I would just like to reiterate that, again, the convention, and this, I hope my point has come across clearly, the major point I try to make, which is that the Istanbul Convention is not only an instrument that seeks to tackle and combat violence against women, including domestic violence, but it's also a gender equality instrument. So it is a gender equality instrument, first of all, because of the way in which it understands the problem of gender-based violence against women as a gender inequality problem, and also because of the way it frames the responses to tackle these problems. So these are basically equality responses, or responses that seek to achieve de facto equality or substantive equality, gender equality, responses that seek to eliminate discriminatory practices towards women, discriminatory stereotypes towards women, and any other negative views or attitudes or beliefs or behavior that may sustain that kind of gender hierarchy, or the system that have historically put a woman in a subordinate place in society. So for all these reasons, and also for the ways in which especially the Grevio's work has addressed intersectional discrimination, I would argue that the convention is a strong gender equality instrument. There are many other ways in which this commitment to equality manifests itself in the convention text, but I would just like to stop here and stick to those parts of the convention in which I think this commitment is most evidently found. There are more, and I'm happy to discuss that during the Q&A session, if you would like. But just a final word to conclude my presentation is that I think what is behind the strong commitment to equality, gender equality, on the part of the drafters of the convention, and of course the previous work as well, is a recognition, I think, that the more equal, the more gender equal a society is, then the less gender-based violence against women will take place. So I think that's the major understanding underpinning both the convention text and also previous equality work so far. So with this, I stop because I do want to make sure that there's plenty of room for questions and comments and critiques. And thank you again, everyone, for listening and for joining.
Dr. Peroni, thank you so much for your magnificent and enlightening speech. I hope the rest enjoyed a lot, because I did. Now 15 minutes Q&A session just start, and the participants, you are allowed to type your questions up, or oral questions you may use to. Let's wait a bit. Before the questions come across, I would like to ask a question, Dr. Peroni. I was wondering, since the Turkey withdrew from Istanbul Convention, which Istanbul Convention provides gender equality, as you mentioned, in a detailed way, you know, CEDAW also, Turkey is a part to CEDAW, and as far as I saw on your resume, you worked on CEDAW too. The CEDAW can be enough to maintain gender equality for Turkey, at least?
Well, the CEDAW actually has done terrific work and has been, I mean, if you look at, well, it is a gender equality instrument as such, unlike the Istanbul Convention, which is, I think, technically speaking, a violence against women instrument, so an instrument that seeks to combat violence against women, while CEDAW, the CEDAW Convention, is a gender equality instrument. But in practice, the strong work that the CEDAW Committee has done on violence against women, including, you know, several general recommendations on this particular issue, I think, yes, indeed, it can be a very helpful and strong instrument if a country, if a state actually is a state party to CEDAW. Having said that, I think, of course, having the Istanbul Convention, I would argue there is, even though CEDAW itself, I would say, might be enough, because especially of the strong work that CEDAW has done both on gender equality and on violence against women. I think the Istanbul Convention may offer an added value because of the specific monitoring work on this particular aspect of, or this particular manifestation of gender equality, which is violence against women. So it is an instrument technically and specifically devoted to this problem, and it sets out a wide range, I think, of positive obligations on states. Again, I was just mentioning just a few of them, focusing on the prevention obligations, which are quite strong and quite detailed, but also, as you know, and as you've been discussing throughout the sessions, effective investigation sessions, criminalization obligations, etc., that are quite detailed and strong and specifically dealing and tackling the issues. So I think it does offer an added value, because within the UN, unfortunately, and despite the CEDAW committee's work, there's not a human rights instrument specifically devoted to combating violence against women. So there is a declaration against violence against women, but there's not a legally binding instrument, even though, again, the CEDAW committee has done terrific work, and I think it's been at the front of the developments, the major developments when it comes to violence against women. But the Istanbul Convention, being a technically, specifically devoted, legally binding instrument for Europe, right? I mean, regional. CEDAW is a global instrument. I think there is an added value, and I think, yeah, I think it would be the Istanbul Convention is a nice complement. Let's put it that way. It's a nice and necessary complement to the work of CEDAW. It's the same with, for example, the Belém do Pará Convention, which is the Inter-American Convention that seeks to combat violence against women in the Americas region. The monitoring body has been doing terrific work on the forms of violence that sometimes are more pronounced or that are more commonly spread in the region. So I think having also a regional instrument apart from a global instrument that is legally binding for that region, I think is an added value, because in part, again, it helps address sometimes regional problems that are regionally present and that might not be equally pronounced in other parts of the world. So I think the short answer to your question would be yes, CEDAW is a great instrument, and I think it can be a very effective global instrument. I think that the work of the CEDAW committees has been very strong in that respect when it comes to both gender equality and eliminating gender-based violence against women. But I think regional instruments such as the Istanbul Convention that specifically deal and technically deal with the problem at the regional level is a very strong complement and a necessary complement to the work of CEDAW.
Oh, yes, thank you so much.
I'm not sure I answered the question fully. Yeah.
No, you answered really well, and I accept your point. Thank you so much. By the way, Professor Sözer sent WhatsApp me a message about your presentation, and please let me read it for the record and also for you too. I will send it via chat session too. He said, "My dear colleague Lourdes Peroni, thank you very much for your contribution to our Law on the Bosphorus Summer School with your work titled Gender Equality in the Istanbul Convention. You have very explicit and informative on the topic. There is a huge misunderstanding regarding gender equality in Turkey. Thanks to you and your participants have a clear image in their head. Moreover, this is our first event with you, but I hope that our work will continue for the future. We follow and appreciate your studies on human rights, specifically equality and non-discrimination, gender and migration and gender-based violence, and feminist legal theory. We will continue to increase cooperation and joint studies in order to benefit from your experiences mutually, hopefully. I would like to thank you for your contributions again, and I hope we will see you in another event soon, face-to-face. All the best, Professor Adem Sözer."
Well, thanks very much for such kind words, Professor Adem Sözer. I also very much hope that this is just the first of a series of contributions and collaborations, and hopefully indeed we will next time we'll be able to share our comments, share our thoughts in face-to-face, in person, and not just online. So indeed, I very much agree, and I'm glad to hear that it has helped clarify the topic of gender equality a little bit, that my presentation has helped clarify the topic of gender equality a little bit. I have to say that equality as such, as you're probably aware of, it is a contested concept. So even, within gender equality, more specifically, even within equality academic scholars who are experts on equality and gender equality, sometimes there's not a big agreement on what equality means, as you probably are aware of. There is an interesting debate I find very illuminating, and it's been published, I think, a couple of years ago in a law journal called Icon. And it's a conversation between Catherine McKinnon and Sandra Fredman on what substantive equality means. And you can see the differences and the different understandings that the two scholars have of equality, of substantive equality, more concretely of gender equality. So I have to say it's a contested concept. The Istanbul Convention, as I mentioned, adopts a substantive, expressly a substantive conception of equality. And that again, there is, substantive equality is itself a contested concept. So there is some agreement, but not full agreement on what it means. But I think there is agreement that on the fact that substantive equality aims to actually achieve equality in reality, and not just in the laws. So that's something I think it's quite important, and I think that's another added value of the Istanbul Convention, unlike other instruments dealing with violence against women, is an instrument that expressly says, well, we aim to achieve substantive equality, so a very robust form of equality. And again, it sets out a series of measures that aim to achieve that kind of equality.
Okay.
See that.
Also, for the record, let me read the question what Hilal Chakra asked about intersectionality. How can we regulate a law from an intersectional perspective? Even though Istanbul Convention has very intersectional elements in it, it can be open-ended because of its inclusiveness. While trying to ensure intersectionality, sometimes we can mistranslate or misunderstood the terms in different cultures and languages. How can we solve this out? She asks.
Well, thanks very much for your question. Indeed, that's another great question, because intersectionality is also a concept around which there are differences, or there are different understandings, even in legal scholarship. So I would say there are two major ways of understanding intersectionality, at least in the scholarly literature that examines intersectionality. So one strand or one part of that scholarship usually refers to the interaction of identity categories. So intersectional discrimination would be discrimination on the basis of a combination of different grounds of discrimination. So for example, sex and gender and sexual orientation, or minority status and language, migration status plus gender. So one strand of scholars within the intersectionality literature see it that way. So it's intersectionality is the intersection of multiple grounds of discrimination, such as the examples I just gave. And there's another strand, or another group of scholars within the intersectionality literature that see that this is not actually a problem of interacting categories of identity, but actually a problem of interacting systems of oppression. So what interacts is not the identity categories, those are the result actually of the systems of oppression. What interacts is those systems of oppressions at the root of those categories, which are sexism or racism, for example, or ableism and classism, migration, restrictive migration rules, and gender rules, or sexism more concretely. So it is these different systems of power, different systems of domination, of oppression, the ones that are interacting. And those indeed might be even more difficult to spot for judges, for courts, but also for legislators. How you regulate that in the law, that could be quite a challenge. First of all, because as the commentator just mentioned, there are different understandings on the topic. And again, if you adopt the understanding that actually tries to unveil the systems of oppression behind intersectional discrimination, that's even more difficult to address in the law. But for example, recently the Council of Europe, they have issued a recommendation on sexism. So it's a recommendation that aims to tackle sexism in the Council of Europe. So there you can see an example. Well, it's not technically a legally binding instrument as it would be, national legislation. It's a recommendation, but it does try to reach to a system of oppression, which is sexism. And I'm not sure I cannot recall whether that recommendation tries also to reach out to the interaction of sexism and other systems of oppression. But my sense is I wouldn't be surprised if they do that. But that may be, for example, an instance of an instrument, again, not legally binding, but at least a human rights instrument that is trying to reach out to the system of oppression itself. So then one step further, or one intersectional step further, would be to go and see how that system of oppression, in this case, sexism, interacts with other, like racism, for example, in the law. So I think identifying at least the identity categories in the law, saying, okay, well, some groups of people, well, in this case, groups of women, may experience even worse forms of discrimination or compounded forms of discrimination because of the interaction of different axes of discrimination, and identifying those combinations in the law would be a nice step, I think. Or the legislation can go even further, and that's, I have to admit, is even more challenging, and go even further and identify the kinds of systems of oppressions that interact to reproduce intersectional discrimination. But again, in some, it's a difficult and it's a challenge because, again, because of the different understandings that are out there on intersectionality, and specifically one adopts the structural understanding of intersectionality that may be even more challenging, you know, reaching out to the systems of oppression, identifying them, and then one step further, the interactions between these different systems of oppression.
Thank you so much. And I think Hilal get enough from your detailed answer. Yes, she said this. So if no more questions left, we can close the session. Thank you so much, Dr. Peroni, for being with us today. We enjoyed a lot for your participation, and hope to see you again upcoming events related to your major and your work. So thank you so much.
Well, thank you again for inviting me, for having me. Thank you everyone for being here, for joining. And if you do have more questions or comments you'd like to share with me, please feel free to share my email address with the participants. So I'll be happy to respond also in writing by email if some people, you know, think of other questions afterwards.
Thank you so much, and take care of yourself.
Well, you too. Thanks again. Bye-bye.